Welcome to Strange But True. Take a breath, slow down, and listen carefully. Some stories are documented, some are debated, some refuse to be explained. We tell you the stories. You decide what's true. Now, let's begin our journey. In early modern Europe, courts did not only prosecute theft, assault, or murder, they also prosecuted something else: lycanthropy. Not as metaphor, not as folklore, but as a legal charge. Between the 15th and 17th centuries, court records across Europe document trials in which individuals were formally accused of being wolves. These accusations appear in France, the German states, Switzerland, and regions of Eastern Europe. The surviving documents are not rumors or later retellings. They are legal records. Indictments were written, charges were read aloud, the accused were confined. Proceedings followed established judicial procedure. Witnesses were summoned. Testimony was sworn. Statements were entered into the record. The accusation was not that the individual believed they were an animal. The accusation was that they were one. Court transcripts describe attacks attributed to animal form, nocturnal violence, and physical traits said to confirm the charge. Some records mention bodies covered in hair. Others describe eyes reflecting light, teeth appearing altered, or strength exceeding what witnesses expected. These descriptions appear alongside dates, locations, and official seals. Judges did not pause proceedings to question plausibility. They evaluated testimony according to legal custom. In several jurisdictions, lycanthropy trials were conducted under the same legal frameworks used for violent crime and heresy. Interrogations followed established methods. Confessions were recorded. Sentences were pronounced. Sentencing language in these cases followed established legal form. The documents list names, dates, locations, and charges in the same format used for other crimes. There is no special category created for lycanthropy. Punishments varied by region, but followed recognizable patterns. Some accused were executed, others were imprisoned, some were burned, some were banished. The reasoning for the sentence is rarely explained. In several records, the judgment is delivered without restating the accusation in detail. The verdict assumes the charge has already been settled. Appeals are uncommon. Reversals are not recorded. The documents do not preserve doubt. In some cases, confiscation of property is listed alongside the sentence. This indicates the charge carried legal weight beyond belief. It affected inheritance, ownership, and family standing. Family members are rarely mentioned afterward. There are no surviving records indicating how communities responded once sentences were carried out. The archive does not record protest. It does not record disbelief. It does not record resistance. The system proceeds, records the outcome, and closes. Medical authorities were sometimes consulted. The term lycanthropia appears in contemporary medical writings, described as a condition involving delusion, melancholy, or animal identification. But the legal documents do not resolve this distinction. In multiple cases, medical language and supernatural accusation appear together in the same file. Neither replaces the other. Neither is prioritized. The case of Peter Stump in 1589 is among the most detailed. The court record described criminal acts, alleged transformation, and culpability within the same narrative. The sentence addresses all three. Execution followed. Other cases are preserved with less detail, but the same certainty. In France, legal scholars debated whether lycanthropy constituted possession, illness, or heresy. These debates survive in marginal notes and legal commentaries. They do not alter verdicts. No statute clearly defines what constitutes a werewolf. No legal code outlines a method for verification. No standard of proof is recorded, yet prosecutions continued. The system functioned without a stable definition. By the late 17th century, accusations of lycanthropy begin to disappear from court records. There is no decree ending such trials, no reform recorded. The charges simply stop appearing. Courts move on to other matters. The archive does not explain why. What remains are the documents themselves. Formal language, recorded testimony, official judgments, sentences enforced under law. The record preserves action. It does not preserve explanation. Whether these cases reflect belief, fear, illness, or institutional momentum is not resolved in the archive. The courts did not explain, they only acted. History has a way of hiding the truth inside what it chooses not to explain. Inside tales, inside myths, inside legends, inside things that feel just a little off. If this story held your attention, subscribe to Strange But True, because sometimes what sounds unbelievable is exactly where the truth hides.